Nitish, I think we can start. We have started the live stream as well. So people who want to join, or they can see that video later on through our YouTube channel.
Yeah.
Okay, I'll start with your
Yeah.
introduction first. So welcome Nitish to this insightful webinar. Thank you for taking out time for us.
My
Nitish is a lawyer by profession, has expertise in taxation, corporate, and cyber law. Currently working as associate partner at Singhania and Co. LLP, and he will be enlightening us with the compliances and organizational structure what a startup should have. It's a very helpful web. It's going to be a very helpful webinar for early stage startups and existing startups who are incubated with us. Over to you, Nitish.
Yeah. Thank you. I will just share the screen with the PPT and we can like take it forward. And just to brief, if I will complete each topic, and if anybody has a question, they can ask me
Yeah,
topic wise.
the audience who are seeing us can just raise their hand simply, and I will unmute you. Then you can interact with Nitish. Then.
Okay. Thank you. So basically, to start with, what startups are. So basically, to be recognized as a startup under the Startup India initiative by the Departmental of Promotion of Industry and Internal Trade (DPIIT), a company has a certain criterias they have to meet so that they can be recognized as a startup. So just to start with, the period of existence or operation should not exceed 10 years from the date of incorporation. They should not have an annual turnover not exceeding 100 crores for any of the financial years since its incorporation. Entity should not have been formed by splitting up or restructuring or already existing business. So basically, there can't be any subsidiary for that matter. Should work towards development of improvement of a product, process, service, and should have a scalable business model with high potential, which can create wealth and employment. So, which companies can be registered as a startup or entities for that matter can be a private limited company, a registered partnership firm, or a limited liability partnership, which can be recognized as a startup as entities. The benefits of a startup, being a startup, what benefits are being provided to you. So there is a reduced regulatory burden, which directly basically is reduced low cost of compliances. The DPIIT startups are either incorporated as a private limited company or a LLP and incorporated, and those entities which are incorporated up after April 1, 2016 are eligible to apply for income tax exemption under 80 IAC of the Income Tax Act and are exempted for 3 consecutive financial years out of their first 10 years since the incorporation. DPID recognized startups are exempted from angel tax now pursuant to the new budget of 24-25. So basically, there are easier public procurement norms like online procurement platform for government ministries and departments, and mostly used channels for public procurement in India. So MSMEs, DPIIT recognized startups and other private companies can register on GEM platform as sellers and sell their products and services directly to government entities now. So GEM Startup Runway is a new initiative launched by GEM to allow startup to reach out to various government buyers by offering innovative products which have unique design, process, or functionality. There are also benefits for the patent and IPR applications, which is a fast track for startups basically. So if we go how the incorporation process runs for each of these entities, to start with the partnership firm, registration of firm is not compulsory. The maximum can be 50 partners if not registered. Basically, the partners execute a partnership deed. The partner should make an application to the registrar of firms of their respective states. So basically, documents required to register a partnership firm is application form signed by all the partners, affidavit by all the partners, certified copy of the partnership deed, and the proof of ownership of place, rent agreement, or NOC in case of the owner is one of the partners. So the basic difference is, if the partnership firm is not registered, is that then in the name of the partnership firm you can't file a case basically as the separate legal entity. So then comes the limited liability partnership, procurement of DIN, DPIN, and DSC digital signature for all partners. DIN is director identification number. Then you have to get the name of the LLP approved by MCA, which is Ministry of Corporate Affairs. Then you have to execute a LLP agreement between all the partners, which will basically govern their who will be the designated partners and the terms of their arrangement. Then we have to file e-form Philip on MCA. The documents required are consent of all designated partners, LLP agreement, identity and address proof of partners, proof of ownership of place, rent agreement, and if you one of the owners, then the NOC, and list of objectives of LLP, that what will be the object of the LLP, what business they will do. Then comes the private limited company. Spice form on MCS file. First, you have to get the name reserved, and then you have to take DIN, PAN, TAN, employment provident fund, employee scheme for insurance, bank account, professional tax, and GST. Then you have to prepare the charter documents. What we call is the memorandum of association and article of associations. And documents required are INC 9, which is a declaration by subscribers and directors, DIR 2, which is consent of directors, MBP 1, which is interest of directors, then proof of ownership along with business, which is like not older than 3 months of a utility bill. Then, if subscriber does not have a director identification number, then PAN, proof of identity, and residential address. Dematerialization of shares is mandatory if you are not a small company. So basically, these come in more scope for a CS to incorporate the entities, uh, and they have to basically do all this work. But as uh, entrepreneurs and as founders, you should have basic knowledge how the entities are incorporated. So, any questions you have in the
We have a
incorporation?
question from Archana Nagarajan.
Okay.
Uh, she asked that can a proprietor go on to have a startup?
So basically, see, proprietor can start a startup, but the implications are they won't be recognized as a startup under the DPIIT, because only a private limited company or a LLP can be recognized as a startup. And basic issue, if you are being a starting your own venture and you foresee investments in the company, no investor will invest in a proprietor, because there is no equity they can hold by investing, right? So proprietor is same as running your own shop or having your own business. So yeah, basically you can't be recognized as a startup being a proprietor.
If anyone has any question, they can just drop the question in Q&A box or can raise their hands. As of now, we don't have any questions, Nitish. We
Okay.
can move ahead.
So now comes the compliances part, and this plays a lot of vital role during the due diligence process. When any investment is made in the company, the investor go through a process of due diligence, which consists of two part: legal due diligence and financial due diligence. So under the legal due diligence, what comes up is all the mandatory filings that needs to be done by the company, all the licenses, approval for running the business the startup is running, do they have those or not, or all the major agreements they have with their vendors or suppliers, and if they have done any prior round, then the respective definitive documents such as per the security share subscription shareholders agreement or a CCD agreement is in place or not, and then all the filings in respect to the issuance and allotment are done properly or not. So there is like compliances bifurcated under annual and biannual. These are general what a company needs to do. So basically minimum of 4 board meetings. Exemption is to start up to have 2 annual journal meeting, maintenance of statutory registers. Form DPT3 is return of deposits. DIR3, that is KYC for directors. MGT7 is annual return, and AOC4 is filing financial statements. DIR8 is intimation by director of disqualification, and Form MBP1 of notice of interest by director. So these are annually filed by each company. Biannual comes the MSME outstanding payment compliance, which is on the company through Form 1. So basically, if you go by partnership firm, as I told earlier, registration of the firm is not compulsory. If not registered, no separate status of a separate legal entity is given, and cannot file cases in the name of the firm. You need a shop establishment certificate for partnership firm also. Then for LLP, registration of LLP, filing of ROC forms, which is Form 8 for statement of accounts and solvency filings. Then Form 11, which is annual return. Form 3 is filed whenever there is a change in LLP agreement within a period of 30 days. So if there is any modification or amendment done to your LLP agreement, then you need to file it with the ROC. Then Form 4 is change in partners. That is also within 30 days. Audit applicability kick in only when the contribution is 25 lakhs by each of the designated partners or turnover exceeds 40. You need PAN and TAN for LLP. Private limited company, registration of the company, INC 20A is commencement of business, which a company needs to file before commencing the business operations. Minimum 4 board meetings, exemption to startups, then again annual general meetings, statutory registers, return of deposit DPT3, DIA3, which is application for KYC of directors. MGT7 is annual return, and AOC4 is form of filing financial statement. DIR8 is intimation of disqualification by director. If the director is disqualified by any other company, then they have to intimate through this form yearly to the company they are directors in. And MBP1 is a notice of interest by director if they hold interest in any other company. So statutory part, which is a part of the compliance, as I told, for the private limited company. So these are the mandatory registers to be maintained by all companies, which is Form MGT1, which is register of members, equity and preference shares holders, register of directors and KMPs, which are key managerial personnel and their shareholding, register of share allotment. So whenever the company takes investment and issue shares, allot shares, then they have to maintain a register for the same. Register Form MGD2 is for register of debenture holders if the company has issued and allotted debentures. Register of loan and borrowings, if the company is taking loans and borrowing money, then they have to maintain this register. Form SH2 is register of renewed and duplicate share certificates. In case the company has issued duplicate certificates to the investors or the shareholders. Form CHG7 is register of charges. If the company has created charges on their assets and taken loans. Form SH6 is register of employee stock options. So if a company has a ESOP policy and they have issued stock options to their employees, then they have to maintain register in the form SH6. So any questions in the compliance or the registers part? Hello.
Someone has no. Okay, it's mine only. Nobody has raised their hand yet,
Okay.
and we
Okay.
don't have any
So,
questions.
okay. So the next part comes the type of securities and companies. So for any investment you are raising as a startup or a company, you need to have a knowledge about the types of securities which a company can issue. So it is like bifurcated into equity, preference, debentures, and convertible note. So to start with, equity shares represents ownership over the company through common stock. There is no fixed dividend given on equity. Shareholders have voting right in the company. They are not redeemable. Shares are, however, transferable subject to the conditions, if any, in the shareholders agreement. For example, there is a right of first refusal right, or there is a lock-in, or on the shareholding. Leads to fast dilution of shareholding, like that is easy to transfer. Types of securities are equity shares and differential voting rights. Then comes the preference shares, represents ownership over the preferential stock. There is a fixed dividend given on that. Voting rights may be modified in the AOA as per the definitive documents. They are redeemable or convertible into equity. So the maximum time frame is 20 years. After that, they are redeemable automatically. Delayed dilution in shareholding, because they are converted into equity, and it's more easy to let's just directly transfer equity shares. So there are two types of preference shares: optionally convertible preference shares and compulsory convertible preference shares, which we call OCPS and CCPS. Then comes the debentures part, represent debt provided to the company. There is a fixed asset interest which is given. There are no voting rights. So basically, debentures are a debt given to the company. So, or at the time of issuance, you don't become a shareholder directly in the company. So redeemable or convertible into equity or preference, maximum within 10 years. No dilution in shareholding until converted, as I briefed before, that once you invest and like the investor gets the debentures, they directly don't come on the shareholding cap table, but they come at the time of conversion. And as per the CCT agreements, there are different conversion terms. So there are optionally convertible debentures, compulsory convertible debentures, and non-convertible debentures. Then comes the convertible note. Investment done are startups without valuation, as conversion price is determined upfrontly. So basically, uh, convertible note can only be issued by startups. There is no dividend, there is no voting right. They are just redeemable or convertible into equity, maximum within 10 years. Same as no dilution in shareholding until converted. So basically, any question on the types of securities?
There are no questions, Nitish.
Okay. So basically, investor and funding preferences, if we talk about the practicality, the real market scenario, uh, as I told you earlier, the question raised by one of the attendees that a proprietor can uh, be recognized as a startup or can take investment by an investor. So investors usually choose to invest and fund a private limited company over other forms of entities. In sole proprietor and OPC, there is only one member, so it is not possible to receive funding in the same. Private limited company provides better decision making powers and management, as there are directors, board seat, shareholders separately, shareholders agreement separately, which governs the right and obligations, the restrictions on the promoter shareholding, and through taking a board seat and having various rights like reserve matters, affirmative vote items, they have a better control over the governance part in a private limited companies. Investors may offer additional governance provisions through executing a triple SHA or a shareholders agreement, what we call. Uh, as I told, basically the rights like ROFR, tag along, drag along, the exit right. So everything is the rights and obligations, and the everything is defined and detailed in a SHA. Investor can choose from various type of securities like equity, compulsory convertible, optionally convertible, compulsory convertible debentures, and convertible note. So, how a deal structuring work, to be precise, is before any investment goes through, first the investor and the company signs a term sheet, which basically is a initial document which ascertain the rights and of the obligations, which and the subscription amount that the investor will invest. And after signing of the term sheet comes the process of due diligence, which is financial, legal, commercial, or personal. So basically, the investments are always subject to the due diligence. So once the due diligence is done by a company, all the documentation filings are reviewed by the lawyers or the respective CAs under the financial part. Then condition precedents and condition subsequents are made, which are a high risk and a low risk point. So condition precedent are all the conditions that a company and the promoter needs to fulfill before the investment is done in the company. And CS are the less risk or the normal things which can be completed once the investment amounts is remitted in the accounts of the company within a period of 30 days or 45 days as mutually decided between the parties. So due diligence might happen. So for all the startup, your filings, your documentations should be in place, because the investment might go away if during the due diligence a lot of non-compliances are raised, or till the time the CPs are completed, the investment are not made in the company. So once you sign the SHA or the definitive document, then there is a time till closing where a CP satisfaction certificate is issued in accordance to the due diligence that the company has fulfilled all the CPs. So just to be compliant with all the filings and approvals necessary, or the licenses necessary for the business you are in, plays a vital role. Definitive agreements depend on the type of instruments, or the security varies from SHA, CCD agreement, convertible note agreement, private placement, and there are modes of issuance, right? Private placement and right issue, so which we'll cover the next slide in. So that is how the issuance is made. Closure of issue is allotment of securities, filing with MC, and issue of certificates, which can be share certificates or debenture certificates. So modes of issuance cover two modes: private placement and right issue. The way the issuance and allotment is done in any company. So private placement is basically you have to obtain a valuation report of the company, open a new bank account. So anytime you take an investment from an investor, a separate bank account is required, which is a major non-compliance for a lot of the startups. So what they do is they take the money in the same a running business account, but anytime you make the issuance to the investor, then you need a separate bank account, and that bank account you can't. So the law says that every private placement, there investment you take, there is a new bank account, right? Separate bank account. So that separate bank account means basically, you can't use this account for day to day operations for the business. So basically, if you take an investment in this bank account, you can, after the requisite filings are done, you can transfer it in your company's bank account and keep that account as normal. Don't do any transactions from that account, and then for the next investment you can again use that. So the basic context is you can't use that account for the day to day operations. Then conduct board meetings for issuance of securities, conduct EGM. Then because of EGM you have to file MGT 14, which is 30 days from passing of the board resolution. Then circulation of pass 4 letter of offer to the investors. Then they sign part B of the pass 4 and send you. Then there is transfer of application money. Then there is a board meeting for allotment of securities. And once that is done, then you have to file pass 3 with ROC within 15 days. Then you have to issue share certificates within 60 days from passing of board resolution, and record the details in register of members. So the basic difference between private placement and right issue is, uh, right issue is done when you are giving shares to the existing shareholders of the company. So in that case, you prepare a letter of offer, uh, which is valid for at least 15 days, but not more than 30 days. Conduct board meeting. Existing shareholders shall accept, reject, or renunciate their offer. Share application form along with the share application money to be received by the company. Then you have to conduct the board meeting for allotment, and then again file pass 3 for allotment and issue certificates. So basic difference between private placement and right issue is obtaining of a valuation report and doing each filing of MGT 14 basically. So that's the difference between two, and that this you can only right issue mode issuance can only be done when you are giving it to the existing shareholders of the company. Any question anyone has for the modes of issuance or the deal structuring, or how investor have a preference over the transaction? Hello.
We do not have any questions, Nitish.
Okay.
If anyone wants to ask or want to interact with Nitish regarding anything,
Yeah.
any of what is not covered in the PPT, also they can just raise their hand and I'll unmute them. We don't have any hand raise.
Okay.
Yeah. So this video is available on YouTube Live. If anything you have missed in between, you can just go back to our incubators YouTube channel and you can access again. Thank you.
So basically, the common issues found in PEVC transactions, which is private equity venture capital transaction, is IPR. Generally, what happens is the IP is registered in the name of the founders or totally unregistered. And legally, it should always be in the name of the company because it's the asset of the company and the promoter investors are invested in the company, right? So each time if it is in the name of the founders, then a respective ip assignment agreement is done when we do due diligence and make it as a cp and transfer the ip in the name of the company. Then comes the non-compliance with respect to companies act for disclosure non-disclosure of terms of use and privacy policy on the website, or the details of the governance officer, grievance officer and all on the website as per the companies act. Then transaction with the promoters, non-compliance are there, certain like the agreements are not drafted properly, uh, or the loans are given by promoters in that way. Then companies act, basically non-filings, no have not maintaining annual filings or maintaining statutory registers, conducting board meetings or egms in a proper way, and or for that matter the filings for the investment are not done, or there are a lot of non-compliance in the timelines in respect of the private placement done. Like I told you, so there is a way the investment can be taken by the investors. So first you file mgd 14 after for the issuance part, and then you give send pass for to the investors and they sign pass part b of the form, and after they give that, then only they can transfer the money. So the basic non-compliance which is done by the startup is once they get the money, they start using it, but they need to understand that till the time you have not filed pass 3, which is return of allotment, you can't use that money. So it is a major non-compliance, and the penalties for the non-compliance of private placement is up to 2 crores. So a lot of times, a lot of startups, because of the short runway, they use the money as soon as they get in their accounts, but they need to understand that it is a major non-compliance as per the Companies Act. That is a thing they should keep in mind. Agreements mean there are no founders agreement or there is no employment agreements between the uh, promoters and the company or the employees. Or if they, if for example you have developed, you have a website and you have developed it through a third party vendor, right? So there should be proper agreement with that vendor in which the source code belongs to you and stuff like this. So these are the common issues which are generally found and then corrected by us during the due diligence process by keeping what is possible as condition precedent, and then certain things at condition subsequent, which can be completed after the investment is remitted and within a period of 30-45 days. So yeah, if any questions on these topics.
We have a question. Uh,
Yeah.
so Archana is asking, since as a proprietor can't become a startup, is
Yeah.
there a separate process to go on to become a venture company, or is it is the same process?
No, so basically, what they have to, like being a proprietor, what now she has to do is incorporate a private limited company, uh, get the name search and all the process done. Uh, if she has a brand right now, get the trademark done for that brand in the name of the company. So she has to incorporate a private limited company for that matter. So proprietor is a separate thing. Now she has to go for proper filing and get a company incorporated. And for that matter, she has to go for the name search if that name is available. Uh, and then give, like, that's the process of incorporation that needs to be done.
Hope your question was answered, Archana. We have Ashish with us who is raising his hand. So I'll just allow him to speak. Ashish,
Hi.
you can ask your question.
Okay. Hi, Nitish.
Hi.
So with respect to bank account opening under private placement
Yeah.
process, so suppose if a startup is raising multiple rounds, right? So
Mm.
that one separate bank account will work for each of the round, or every time
Yeah.
he has to approach to the bank and open a separate bank account
No,
within the
no.
name of that
So
specific round.
no, no. So that's not how it functions. As I briefed you earlier, the basic non-compliance which occurs for startup and how. So what we have to do is the separate, but for the time you went for a investment round, right? You opened a separate bank account. Just don't use that account for the day-to-day operations. So
Okay.
basically, like, you keep a separate current account for your business. For example, for the first time you are going for a private placement, right? For investment. So open a separate bank account, take
Mhm.
investment in that account, then
Okay.
don't use that account for day to day operations. Once the money comes in, transfer it in your company's bank account and use it from there. Keep that
Okay.
account separately. So there should be, so you can use the same bank account till the time there is no day to day operations conducted on that.
Okay.
So you don't have to
Suppose.
open again and again. Just be
Okay.
compliant that and aware that you're just transferring the investment amount in your company's account and not using that account for the day-to-day operations.
And in the next round, I can utilize that new bank account again, right?
Yeah. That's the thing. So it's
Okay.
a thing that you should keep in mind as a founder, that that's how it needs to be done.
Okay. Thank you.
Any
Thank
other
you,
question?
Ashish. We don't have any other question. You can continue.
So now we comes to the labor law applicability. So basically, Provident Fund Act, basically the compliance apply when you have 20 or more employees. Employment scheme of insurance, basically when you have 10 or more employees. Factories using power, otherwise 20 or more. Maternity benefit policy and compliance is there in case you have any woman employee. Bonus Act kick in when you have 10 or more employees. Factories Act kick in when you have 10 or more employees. Contract labor, 20 or more workmen. So basically, when we say employee should be on your payroll, and respective employment agreements needs to be signed with them. So these are also the compliances which kick in when you are in a manufacturing or in general service industry. So as soon as this threshold crosses, you are entitled to get yourself registered and do these compliances of labor laws. So yeah, this is it, covering all the topics for the PPT.
Thank you, Nitish. Uh, is there any question anyone wants to ask? We have a question from Shubham,
Okay.
and he asked that have a general partnership and have raised some funds. However, I need to switch to a LLP. Do I need to dissolve the general partnership before moving forward? What happens to the raised fund?
So basically, there is a provision that you can convert a partnership firm into LLP. But yeah, so this is what is available, that a partnership firm, registered partnership, can be converted into LLP, and LLP can be converted into company. So this is a process which you can take. So it's just the partnership firm will be converted into LLP.
Yes, and he's asking that do he need to dissolve the general
No, no.
partnership?
So he won't, because that will be converted. So if it's converted, then all the things will be mirrored to the LLP.
Okay. And what happens to the funds he has raised as of now?
Obviously, everything. So basically, it's like you are just changing the entity, every money and everything, and the respective then shareholdings are like converted to the LLP. So there is Form 17 needs to be filed along with Form 2 for such conversion and incorporation of LLP. So this is more of a company secretary CA work, but it's possible. So you don't have to dissolve; you can just convert. It
Okay.
might be a bit time taken, but yeah, there is a procedure under law.
Anyone else has any question? They can just raise their hand or can drop a message to us or Q&A box. I think we don't have any questions.
Okay.
Thank you, Nitish, for joining and giving time. This was really an insightful session, and
My pleasure.
many of our startups would have uh, like benefited with the session. And also, I will like to repeat, the session is available on YouTube for you guys to access it later. Thank you. Thank you for joining, Nitish.
Thank you.